charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I have reserved my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally.
Welcome to Courtroom Secrets.
Yes, sir, I'm here on special appearance, and I reserve all my rights under UCC 1308.
Okay, good morning.
Good morning.
All right, this is plaintiff's motion for summary disposition. Mr. Tetro, you may proceed.
Thank you, Your Honor. Yeah, this is plaintiff's motion for summary disposition. It's being brought pursuant to MCR 2.116 C9 and C10. C9 is failure to state a valid defense, and C10 is no genuine issue as to any material fact. Excuse me. The evidence that's offered in support of plaintiff's motion establishes that Mr. Everett opened a credit account with plaintiff in November 2016. He used his card to make numerous purchases over the next few years. He accrued a balance which went unpaid. The account went into default, and now the plaintiff brings this count of breach of contract to recover the unpaid balance on the account.
Okay. There was a response filed to the motion by Mr. Everett. Did you receive the response?
I don't believe so.
Mr. Everett, did you file the response with the plaintiff's counsel?
Yes, sir, I have a tracking number. I can track it.
I'm sorry, you have what?
I have a tracking number for the mailing. I can track it.
This was filed back on March 24th, is that right?
Yes, it was sent out the same day, USPS.
What's the title of the document?
Notice of judgment to dismiss for lack of contract and jurisdiction.
It's notice of motion to dismiss for lack of contract and jurisdiction.
Okay, does it also say high priority judicial declaration?
Yes, it does.
Okay, we did receive that.
Okay, would you like to respond to it?
Yeah, so the filing that Mr. Everett has filed, now it's my understanding that this is a response to the motion for summary disposition. It doesn't really address too much of what's in the actual motion for summary disposition. It does talk a lot about the UCC and Fair Debt Collections Practices Act. Most of what the plaintiff talks about, or excuse me, most of what the defendant talks about in his response is not applicable to this case. UCC doesn't apply to consumer debt. The Fair Debt Collections Practice Act doesn't apply to the originators of the debt. Most of it's not addressed to the motion. So, and also it doesn't offer any affirmative or documentary evidence to contradict that which is offered in support of plaintiff's motion. So I think at least as it stands for the C10 aspect of the motion, no counter evidence has been offered. He hasn't created a genuine issue of material fact.
So one of the things argued by Mr. Everett is that there is no contract, and what is your position with regard to the existence of a contract? You said this is a breach of contract complaint.
Yep, there's a contract. There was a contract attached to the complaint that was filed. There's a contract attached to this motion.
Those were signed by both parties?
I don't believe they were signed by any party, but there's no requirement for a signed writing. Statute of fraud doesn't apply to credit accounts. The terms of the agreement that are attached to both the complaint and the motion are clear, and the terms of which are clear and unambiguous, that use of the account is acceptance of all the terms of the agreement.
Okay. Just looking at for the complaint in this manner, it's strictly a breach of contract complaint, is that right?
Yes.
It's not an open account claim.
No, I don't believe so. I think it was just one count for breach of contract.
Okay, Mr. Everett, response?
I wholly disagree based on all of my research and based on all of the listings from UCC, listings from the Internal Revenue Code, subsection 166 on charge-off reporting. My Exhibit A was proof that the account was charged off. That basically prevents financial institutions from profiting from a debt that was already satisfied through other means, which means if it was charged off, they got a tax credit for it. I also listed in here that if they cannot enforce if they've already received benefit. That's just one of many here, sir, that are legitimate and are applicable to consumer accounts and consumer law. Statute of frauds, UCC 2201 requires that a contract for the sale of goods for the price of more than $500 be in writing and signed by the party whom enforcement is sought. They have no signatures. They have no electronic signatures. They have no wet signatures. There's quite a bit of things here, sir, that are not aligning with what the plaintiff is claiming.
Well, let me ask you this. I mean, you did have a credit card that was from American Express, is that right?
Yes, sir.
And looks like you used that credit card for charges at numerous local locations, including Granger Waste Services, Meyer, Capital City Grower Supply, Chipotle, and they haven't been paid for those charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I reserve my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. And I do not accept the liability associated with the compelled benefit of any unrevealed contract or commercial agreement, whether it be adhesion or hidden.
Okay, so you used a credit card and charged it up and didn't pay it off. I mean, that's really what the facts are here in the case. They don't
have any mechanism for enforcement, sir.
Okay, all right. Anything further, Mr. Tetro?
Nothing further other than just to reiterate the fact that he would have been provided with a copy of the agreement when the account was opened. It makes clear that use of the account binds him to the terms of the agreement. He's just admitted that he used the account. So I think the facts are kind of undisputed at this point.
Okay. Well, I do not find that there is a genuine issue of material fact. I find that the defendant did use his American Express card, did run up charges and receive a material benefit by using it, and that obviously he made some payments on the account, which acknowledged that there was an agreement that if he used it, he would pay, and then he stopped paying at a certain point in time and went into default. The court does find that his use of the credit card and acceptance of the benefit of using that credit card to make purchases does constitute a binding agreement, and therefore I do find that plaintiff is entitled to summary disposition of this claim. The various laws that were cited by Mr. Everett are not applicable. And so that's the ruling of the court. I will sign an order. Was there an order, a judgment submitted, Mr. Tetro, with the?
Yes, Your Honor. If you have the motion packet, it should be the very last 2 pages of that whole motion packet. The last 2 pages of the exhibit should be a proposed order, or excuse me, proposed judgment.
It's about a 300-page motion packet, so it's a little bit difficult to.
Should be the very last page.
Okay. Okay. All right. That's all for the record in this matter. I'll sign the order and send it to the parties.
Thank you, Judge.
Welcome. America versus Jason Everett, case number 243844GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
I'm well, thank you. Good morning. And good morning again, Mr. Everett.
Yes, sir.
Okay, this is plaintiff's motion for summary disposition. Mr. Kirschenheiter, would you like to, did you receive the response filed by Mr. Everett in this matter?
I did, Your Honor. It's titled motion to dismiss, the same as the previous case, but we did receive it, yes.
Okay. All right. What would you like to tell the court?
Judge, it's pretty straightforward. It's a credit card claim. It's an account stated claim. It's a C9, C10 motion. We don't believe there's a genuine issue of fact. There's been no valid defenses pled. Defendant opened up this credit card. He used the credit card. Statements were sent to the address that he lists as his address. He made payments on the account. There's a balance due and owing. We've provided those statements showing the use of the account as well as an affidavit as the amount due and owing. Pursuant to C9, only the pleadings may be looked at, and defendants did not technically file an answer. He filed an affidavit under the UCC, does not deny any of the allegations in the complaint. There's no affirmative defenses that have been pled. Under C10, we don't believe there's a genuine issue of material fact. We believe we've got the burden with our pleadings. So we would ask that our motion be granted and judgment enter.
Okay. Thank you. Mr. Everett, your response?
Yes, sir. Again, I had no material contract, no informant consent, no signature, no social security number listed. I reserve my rights to be compelled to exercise any compelled benefits that were hidden from me at its initiation. Same as before, sir. I don't believe they have standing to for claim.
Okay. All right. Well, the court has reviewed both the motion and the response, and it's very clear based on the exhibits attached to the plaintiff's motion that that Mr. Everett did have a Bank of America card and did utilize it or bill was paid or was charged to it. And so clearly Mr. Everett received multiple benefits by using the card. He did make some payments under the cardholder agreement, and at a certain point in time defaulted and stopped making payments. I do find that there is no genuine issue of material fact. I do find that the plaintiff is entitled to a judgment as a matter of law, and I will enter a judgment granting summary disposition for the plaintiff. Mr. Kirschenheiter, was there a judgment submitted with the
No, Judge. I will provide an order to the court.
Okay, you may submit that under the 7-day rule.
Will do.
Okay. All right, that's all for the record, gentlemen. Thank you.
Thanks, Judge. Have a great day.